Hello dear friends, welcome back in our YouTube channel IndusLex, and today we are going to discuss law of arrest, or we can say what is the law which regulating the concept of arrest means a detention by a competent authority. Dear friends, firstly we have to understand this arrest is of two types. One is preventive detention and another arrest is relating to cognizable offense. What is preventive detention? Dear friends, you heard about that. Some people are detained because there is a possibility of commission of cognizable offense. Maybe there will be a free fight, or there may be some dispute regarding property where conflict is there, that group of people may fight with each other. In these cases, police use its power of preventive detention, meaning thereby police give you a notice that you have been detained for the particular period not more than 24 hours, and you have to give bond, maybe a personal bond or some other type, that you people will not indulge in the particular type of case where there may be a conflict regarding that property. This is a preventive detention. Another preventive detention cases we will find when there is some type of curfew is announced by the competent authority, and if more than 4 or 5 people there, then there may be a preventive detention. Power of preventive detention is also used at the time of some type of protest, maybe a student protest, farmer protest. At that particular time and place, police sometimes use this power, that is a preventive detention. Apart from the preventive detention, other detention is relating to the commission of offense. Offense is of two types. One is cognizable offense, another is non-cognizable offense. Non-cognizable offense is of petty offenses in which about 2-year punishment or maybe fine is there. But what is cognizable offense? Statute says cognizable offenses are those offenses in which police has power to arrest. In general term, in those offenses where punishment prescribed by statute is approximately more than 3 years, or for general categorization we can say that offense is in the ambit of cognizable offense. For every cognizable offense, FIR must be registered, meaning thereby when a particular person who is a victim of some sort of offense, if he move a application or a complaint moved by that person to the station house officer, is a duty bound to write down, reduce that complaint into the writing if given orally, or take the copy of complaint and register the FIR. Once FIR is registered, criminal law comes into the motion. After the registration of FIR, police got its power. It is very important that without registration, police has no power to investigate, except in some certain cases where matter is relating to matrimonial dispute, business dispute, or medical negligences. Only in these type of cases police has power, police has option to do preliminary inquiry. Otherwise, if a complainant discloses the commission of cognizable offense, then police is duty bound to register the FIR, and after registration of first information report, that is FIR, police got its power under the statute of the investigation, where police record the statements of the accused or other person who is related to the commission of that particular offense. And after following the due procedure, after completion of investigation, police submit its charge sheet, and after perusing the charge sheet on a particular competent court, that the magistrate court take cognizance. Between taking the cognizance on a police report, that is charge sheet, and initially started from the registration of FIR to the completion of investigation, submission of charge sheet, till the magistrate take cognizance, this is the area where police has to do everything. After that, the investigation, or you can say that the case is continue in the court. Before this cognizance stays, that court, we can say the ball is in the hand of police. Now the police has to decide whether in this case they are permissible to do arrest, because section says cognizable offenses are those offenses in which police has power to arrest without any warrant, and every case which is a cognizable offense, there must be registration of FIR. Meaning thereby criminal case is started from the FIR. Now question arises, apart from the preventive detention, whether police has eminent power to arrest every person in every cognizable offense. Answer is no. The right answer given by the Honorable Supreme Court in Arnesh Kumar versus State of Bihar to Satyendra Kumar Antil versus Arnesh Kumar versus State of Bihar is of the judgment of the year 2014, and Satyendra Kumar Antil versus CBI is of the judgment of in the year 2022, or we can say in 2021-22. Satyendra Kumar Antil is the very prominent case which deals with the personal liberty, and it is most latest case laws. Apart from this, the power of arrest is dealt by the Honorable Supreme Court, to which extent the police has power, and whether the power of arrest mean mandatory to arrest a particular person or there is a necessity of arrest. Court says police has to see whether there is any necessity to arrest the particular accused in the case. Further, court did not put a discretion in the hand of police. Court makes guideline. Even in the statute itself, there is a guideline when to arrest, or if a police officer want to arrest any accused on the commission of cognizable offense, what will be the criteria on which police will judge that whether in this matter arrest is necessary or not. The court says if the offense is punishable below the 7 years, then police shall not directly arrest the accused. Meaning thereby, if the cognizable offense revealed by the complainant or in the FIR, if the FIR discloses the commission of cognizable offense and that offense is punishable below or less than 7 years of imprisonment, police firstly has to give notice to the accused person that on a particular date, on a particular place, you have to appear, say what you want to, what is your version, and then police record 161 statement. Offenses which is punishable by less than 7 years of imprisonment, police has no power to directly arrest the accused. Police has to give notice. If upon giving such notice to that accused person, accused is denying or not appear on the specified date and time mentioned in that notice, then police may arrest him. In meantime, accused may approach the Honorable High Court of the competent jurisdiction to take the direction that police should follow the procedure of Arnesh Kumar versus State of Bihar Supreme Court guidelines. Further, court says if the offense is punishable more than 10 years or above 7 years, including life imprisonment, death, whatever may be, but it must be above 7 years of imprisonment prescribed in the statute, then police has power to directly arrest the accused without giving any prior notice about the commission of offense. In both the cases, Honorable Supreme Court held that the power of arrest is something different from the necessity of arrest, and police has to decide whether there is some sort of tampering of evidence if the accused is not arrested, whether there is chance of absconding of the accused, what is the heinousness of the crime, what is the severity of the crime, and on these terms, Honorable Supreme Court in Satyendra Kumar versus CBI categorized the offences in 4 categories. Category A cover those offences which is below 7 years, where punishment prescribed by the statute is less than 7 years. In these offences, police has to give prior notice and record the statement of the accused. There is no power of arrest. In category B cases, that offences which is prescribed above 7 years of punishment including life and death, in these offences, police may arrest the accused, and if police not wish to arrest the accused, police officer record the reason why it is not necessary to arrest that accused in category B cases where offense is punishable by more than 7 years of imprisonment. In category A cases where offense is punishable by less than 7 years of imprisonment, In these cases, if police is going to arrest any accused, police has to record its reason explicitly that why it is necessary to arrest the accused. In category C, cases are those cases which is covered under the special act such as POCSO Act or Scheduled Caste Scheduled Tribe Act and DPS Act. And category B cases are the economic offences cases where the offence is related to economy. And economic offences is some sort of those cases which is relating to the economy of the nation, such as Money Laundering Act, etc. So the category is very clearly made by the Honorable Supreme Court that police only arrest the accused where offence is punishable by the below 7 years. Then police has to give prior notice, and for the punishment which is punishable more than 7 years, then police no need to give prior notice. In these cases also, after the arrest, after the detention of the accused must produce before the competent magistrate under 24 hours. And if maybe sometime police officer or investigating officer add those section which is punishable by more than 7 years, but in fact when somebody read the FIR, although the FIR discloses the commission of cognizable offense, but not to the such extent which is punishable by the imprisonment of 7 years or more. Maybe the section which added in the FIR or on the further investigation at the later stage, maybe those section is not ingredient of those section is missing in the FIR. Then accused when brought before the magistrate for the remand within 24 hours of the arrest, the remand may be opposed by the advocate on behalf of the accused that the ingredient of such section which is punishable by 10 years of the imprisonment is missing. Therefore, giving remand in this section is illegal if the court is satisfied that look, the commission of cognizable offense is there, but the cases is of such nature that is punishable only to the extent of 7 years, not of 10 years, then the accused may be released as soon it brought before the magistrate will not pass the remand order under those sections. So what we understand is there is two types of detention. One is preventive detention and another is detention relating to the commission of cognizable offense, in which person is brought before the court or his name is disclosed in the FIR where a commission of cognizable offense is disclosed. Then if there is a registration of FIR, then you have to see whether it is under the 7 year or above the 7 year. If it is under the 7 year and police is trying to raid at your house, trying to catch the accused, has a remedy to approach the competent high court to get the direction to comply with the provision that the police give notice first, and if the accused is appearing on the notice, then police shall not arrest the accused. And if the allegation is above 10 year or 7 year or more than 7 year, then accused has right to file an anticipatory bail application, because above the offences which are punishable then more than 7 year, then police is definitely going to arrest you without giving any prior notice. In these cases, you have to move anticipatory bail application in the session court, and if the session court grant you anticipatory bail, then police will not going to arrest you. If anticipatory bail is rejected by the session court, you have to approach Honorable High Court for getting the anticipatory bail application. In certain criteria, you may directly approach the Honorable High Court if there is not functioning of the courts in the session court, maybe due to some long-term strike, non-term availability of the advocate, or maybe your case is of such nature that the advocates are not interested to fight your case, then you may approach to the Honorable High Court. Or if the offense is registered in some different district, maybe you belong to Jaunpur and the registration of FIR is in Bareilly district, then the accused may approach Honorable High Court directly that to move anticipatory bail application in the High Court. One more interesting point is that apart from the criminal jurisdiction, when there is registration of FIR, there may be a chance of malicious prosecution. And therefore, even though in criminal law, accused has no right to say anything before the prosecution evidences are closed and defense witnesses has to be examined in the court when trial is going on. But in the Constitution, Article 226 and Article 21 of the Constitution of India is at the head of the Constitution of India, and the personal liberty which is protected under Article 21 is of utmost importance and care. The individual liberty is of the utmost important, and therefore when you think that the particular FIR is a malicious prosecution against you, you may directly approach to the Honorable High Court in criminal writ jurisdiction. For quashing of that FIR, you may move a writ petition before the Honorable High Court, but successing rate of the writ petition is depend upon that there is no prima facie commission of offence is disclosed in the FIR. Any FIR is only going to be quashed when upon reading the entire FIR there is no commission, there is no disclosure of the commission of cognizable offence, or you may prove by the complete facts that this case is of those category which is come under the malicious prosecution, then your case may be struck down completely and FIR is going to be quashed by the Honorable Supreme Court. Thank you.